My lordship.
Yes.
Lordship, I beg to mention item number 26. On the
26.
behalf of imparting leading counsel, is not feeling well.
26.
Item number 26.
Okay. What do you want?
It's up to you.
What do you want?
After 3 weeks.
Huh?
3 weeks.
On the prayer of counsel appearing on behalf of Mr. Empathy and senior counsel. List this matter after 3 weeks.
3 weeks. Much obliged.
Lordship, I beg to mention item number 28.
28.
Yes, matter may
Yes.
matter may be taken after 3
On the
weeks.
prayer of S.C. Rank so learned counsel will list this matter after 4 weeks.
3 weeks.
3 weeks.
Highly obliged.
May I, Your Lordship? I'd like to mention item number 9 on behalf of standing counsel.
Item
Number
6.
Yes, Your Honor. On behalf of standing counsel, we have taken the consent from the other parties.
Mr.
H. Tai.
Yes, the learned counsel appearing on behalf of Mr. T. Tagum. Learned counsel for the petition. Press for listing the matter after
3 weeks. Your Honor.
3 weeks. Press on list after 3 weeks.
And Your Honor, item number 25.
25.
On behalf of T. Tagum, standing counsel for Health Department.
Same. 25.
Obliged.
Your Lordship, I beg to mention item number 27 on behalf of Mr. D.K. Pangyang.
27.
Yes, Your Lordship.
On the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. Deepang, learned counsel for the petition. List this matter after 3 weeks.
2 weeks.
2 weeks. Yes. Heard, Mr.
My lord,
Yeah.
yes.
Learned counsel for
I've
the petition.
filed a petition under section 49 CRPC, bring
Call-
for granting the release of the Alice accused who was arrested on 28th March 2023. Presently, he is languishing under judicial custody for more than 48 days. So,
48 days.
yes, 48 days.
48 days.
Yes.
Yes.
So, my lord, here,
Next
last
para.
occasion,
Next
this,
para. Heard, Mr.
Yeah.
T. Counsel for the applicant. Next para. This is an application under section 439 of CRPC, 1973. Bring for grant of post arrest bail to the accused person Sri Takar Pakbah, who was arrested on 28/03/2023. 23 or 24? Arrested on
28,
28, 2024 or 23?
24.
24. Well, then why you have written
Minus the-
23?
Yes.
23, 24 lords.
24. In connection with
Ita PS number.
Darlan PS case
Oh,
34 of 2024 under section 21 within bracket small b /27 /29 of NDPS Act 1985. Call for the scanned copy of the case diary. MSL Hagel and additional PP appears on behalf of the state.
My lord, this is subsequent
List-
application.
List after 4 weeks. List after?
Subsequent application.
All right.
List after lordship.
List after when? List when? What do you want?
I want
Yes.
granting bail.
Huh?
The CD may be.
I have completed the dictation. When do you want?
I want as this.
List after 2 weeks. 1 week.
1 week better than
Then-
because accused is under languishing under judicial custody. For about
It's not audible.
yes, audible.
It's audible, not audible.
Yes, audible.
Oh. Next.
Obliged, lordship.
Also.
May I, Lordship?
Joint petition.
Yes, Lordship.
Heard Mr.
T. Gatzel.
T. Gatzel, learned counsel for the petitioners. Mr. This is an application under section 482 of CRPC 74. Bring for enforcement of the. What is the GR case number?
GR case number is 144 of 2021.
Proceedings of GR case number 144 of 2021, corresponding to Naharlagan PS case number 40 of 2021. Under section 341, 326, 34 of IPC, pending before the pending before the Chief Judicial Magistrate UP, Capital Complex UP, on the basis of the settlement amongst the parties, amongst the petitioners. All put a scan copy of the
Lordship,
trial court record.
interim kindly,
The MS Elhagel and SLPP appears for state, pending production of the scan copy of the record, trial court record, the proceedings of GR case number 124.
GR case number 144 of 2021.
144 of 2021, pending before the shall remain suspended.
Lordship, list after lordship.
List after 3 weeks.
Lordship, oblige.
Obliged, Lordship.
Yes, what is this? Wait for the result and file an electoral
Lordship.
petition.
I am from Delhi, Supreme Court Bar Association member to assist my junior. So if the court permit me, I can argue the case.
You have not filed the power.
Wakalat I have given to them.
You have filed it.
Yeah.
If you have filed it, you can. You may. You can.
If Lord permit me, then I can just. So this is a writ petition.
No, I have seen it. I have seen your writ petition. You wait for the result and file an election petition if it's not palatable to you. All right. No replies.
No, my lord, here is because of the jurisdiction of High Court is there. That's why I'm here actually.
There is no
But
jurisdiction.
I'm not
No
going to-
jurisdiction. We cannot exercise jurisdiction in the election matter.
Only 2 minutes, my lord. There is, I have quoted the case of the Ashok Kumar of 2000, where the Supreme Court have already upheld.
You
Yeah, I have.
you are from Delhi.
Yeah.
You are from Delhi.
I'm telling you.
Therefore, we are just issuing notice. That's all. Nothing more. Nothing less, nothing more. At best, notice. And it doesn't deserve notice also. Right?
Right.
Heard, Mr.
No?
Or would you argue on the maintainability?
Yeah.
We'll decide on maintainability today and pass orders. What do you say?
Okay. Okay, my lord, this lord praise like this. Okay, I will agree with this.
It's up to you.
Now,
Are you seriously think that this writ petition is
I have
maintainable?
drafted it. I have seen the case. I have drafted this petition.
Okay.
That's why I
Heard,
know the case.
heard, Mr. Mr.
Yeah.
Your name, please.
P. Kakra, Purushottam Kakra.
Problem है क्या? हाँ, P. Gagra,
P.
learned
Kakra.
counsel for the petition.
I'm practicing advocate in Supreme Court.
By filing this application, the petitioner claims to be a contesting candidate in the assembly election for which one? Which constituency?
11 West.
11 West SEPA assembly constituency, comma. Press for a direction to the respondents to conduct an inquiry on the representation dated 03/05/2024 filed by the petitioner with respect to 5 polling stations. Alleging what? What you have alleged? What you have alleged?
I have reported the cases of the poll capture, booth capture, bogus
In
voting,
respect to five
and
page
the
26,
stealing of
alleging
EVM.
both capturing,
Five constituencies,
both capturing,
constituencies.
huh?
11-7, five constituencies of the
Five constituents, five polling
polling
stations,
names are
namely, huh? Page 26.
And I have submitted total details.
Alleging boot capturing,
Both capturing, then the irregulation in
Comma.
filling the EVM machine, electronic
irregularities
voting machine.
in,
At the certain constituency, and then bogus voting.
irregularities in what? EVM management?
EVM, electronic
EVM?
voting machine.
Yes,
That-
EVM what?
At a certain point, this was sealed without the presence of the polling agent and
Regarding,
And before
comma,
the poll
irregularities
time.
in sealing
before the
the
polling time.
EVMs and
At the Niki, that is poll number 11-19.
etc.
11-19.
Issue notice
Nicking. And then bogus
returnable
voting
by,
at the three polling
returnable
stations.
by 4 weeks, right? Mr. MS and Anju,
For 1 and 5.
learned counsel appears on behalf of, enters appearance on behalf of respondent number 1 and 5. Then who else? What about this 6, 7, 8? 6, 7, 8.
They are private parties, madam.
No, officer in charge,
I'm sorry.
district election officer.
Represented by PP, madam.
Mr. S. Tapin Lanet, senior government advocate, appears for respondent 6, 7, and 8. No, 6 and 7. No, election officer also, you are not representing.
No, Your Lordship.
Appears for respondent number 6. No, list of no formal notice need be served. However, extra copies be furnished to the respondent learned counsel for the respondent number 1, 5, and 7. The petitioners to take steps for service of notice upon respondent number 3, 1, 2, 3, 4, 5, 7, and 8. By registered post within 3 days, 4 days, 4 days. The considering the grievance raised in this writ petition, comma, the maintainability of the present writ petition shall be considered on the next date, list after 4 weeks.
I'm obliged.
David the chair. David is there. David the chair. Heard Mr. So-and-so. David is the discuss. R.L. Thunga. David is the chairs, huh? Yes.
Your Lordship, this is a fresh petition which was withdrawn yesterday
Yes.
after necessary corrections. This has been filed afresh. This pertains to disqualification. Your Honor.
Yes. You are still in Congress, INC,
I'm in INC only.
not inclined to BJP.
No. Your Honor.
Seriously,
Yes, I'm INC candidate.
seriously.
Yes, Your Lordship. I have a certificate, latest certificate. I'm still,
But you have been issued a notice and you have filed a written statement,
no, Your Lordship.
written reply.
Of course, notice is the first limb of natural justice, Your Lordship, needless to say. Of course, I was the show cause notice requiring me to file my arguments, my defense. I was never allowed by the Deputy Commissioner to make my submissions. So being left with no option, that was heard on 29/4. The impugn order is of 29/4/2024, Your Lordship. The hearing was taken up on 29/4/2024, and the final order was passed on the same day.
See,
Same day.
well, I'm inclined to stay the order,
Yes, Your Lordship.
but tomorrow, if you want to join,
Yes,
we'll bar from joining any party to you.
yes, Your Lordship.
All right. The stay will be subject to that condition, that you will never join any other political party.
All right.
All right.
It's all right.
Yes, we'll stay. We cannot give that condition. I'm just on lighter way I've said. That cannot be condition.
I'm just relying upon a very short judgment.
See, where do you keep it yourself? Mr. CW Mantha.
Otherwise,
Counsel for this.
Otherwise, if you should see the impugn order, Lordship.
Yes.
In impugn order, the deputy commissioner himself observed that, given the reason that Lordship, the petitioner, he himself personally appeared before him while filing the no confidence motion against the chairperson. Lordship.
That is something different. That is something different.
So,
That is different proceedings.
that's correct, Lordship. That's the act of the Lordship petitioner.
Hmm.
Against the Lordship,
See, to disqualify, there should be some semblance of proof that he has voluntarily given up.
that part.
That has not been, that opportunity has not been given. Prima facie.
Only my point is when it's admitted, Lordship.
See, she is or he is an elected representative
Correct.
member of the Panchayat.
And in the pleadings also, in the read petition, Lordship, he has not denied all those allegations in the pleadings, Lordship.
But he has raised something.
Here, if Lordship see
He has raised.
if Lordship see the entire pleadings made in the read petition, Lordship, those allegations have not been denied, Lordship.
Okay, we'll go by the
Anyway,
written
And it
reply.
is still, Lordship.
Yes,
If my lord is staying the order,
yes,
I would like to make some argument.
yes.
My lord, the act is silent with regard to the procedure to be followed in case of a disqualification proceeding.
There's a optimum number of judgment of the Supreme Court, and the law is well settled. Unless it is expressly
Excluded. Principle of- Yes, but I'm not saying that principle of natural justice is totally excluded.
yes.
Principle of natural.
Just issue a notice.
Yes,
He has, she has filed a reply. It is not, it's not sufficient.
My lord, to my humble understanding, when the act is silent with regard to the procedure, given the fact that the proceeding is.
No, it's not a question of, we have not said anything that it has the act, the authority has violated the act, provisions of the act. Whereon is the opportunity of hearing has not been given.
I'll make my submissions on principles of natural justice.
Yes,
Principle of natural justice,
yes,
not only procedural.
yes,
When the act is silent, my lord, with regard
Yes.
to the procedure. Since the act provides for time-bound disposal of the disqualification complaint, it is a summary procedure in my humble understanding.
yes.
It is a not a full-fledged trial. In a full-fledged trial, parties are given opportunity to adduce evidence and cross-examination. The right to cross-examination, my lord, flows from the right to examination in chief. That is Indian Evidence Act. Indian Evidence Act per se is not applicable to the proceeding before the deputy commissioner.
Very strange,
My lord, the
very strange argument. Thank you. We'll record your submission. We'll issue notice and stay the,
well, there are other submissions. my lord. Compliance of notice and opportunity to reply is substantial compliance of natural justice. That is one limb of argument.
we'll record it.
Second, my lord, in any case, my lord, she is not entitled to cross-examination. The absence of opportunity of cross-examination my lord, per se will not vitiate the decision which has otherwise been taken fairly. Given the fact that the facts are admitted, undisputed. The fact that she has joined BJP party, voluntarily given up the party of her parent political party, membership of her parent political party is not undisputed, my lord. It is admitted. I would like to place one judgment on that.
You keep it yourself. We'll issue notice and yes, tomorrow you may say that you have not been heard properly again. Again, violation of the principle of natural justice. Is it for passing an interim order? Is the judgment related to passing of interim order?
No, madam, it is in relation to the principle where natural justice is not applicable. In a situation where natural justice is not applicable, where the facts are admitted and undisputed.
Hmm. See, before you show us where the admission,
Sorry, madam.
where is the admission on the part of the petitioner? First you show that.
But the no confidence motion letter, madam, you find at page number 8.
Hmm. We're not on no confidence motion. We're not concerned.
No, madam, that letter has been the basis, is the only basis on the basis of which the deputy commissioner has reached the decision. The allegation comprised of two sets of facts, electronic evidence and this no confidence motion letter, which was submitted by the petitioner along with 6 other members of
Let us
BJP
see
party.
page.
Page 80. Annexure 6.
Hmm.
To the deputy commissioner from members of the place such and such, subject no confidence motion. Madam, with due respect and humble submission, it is to state you that Ms. such and such could not deliver her duty as ZPC era. She has miserably failed in implementing the plans, programs, and policies of the government, thereby affecting adversely the performance of the party. Malord, can you take note of these words? Of the party entities. Moreover, her anti-party activities invite the people's resentment and cases. Therefore, we do understand the claims of BJP era. Would like to go for no confidence motion against President ZPM era under section such and such. Malord, we'll also take note of the fact that this letter has been marked to the president of district unit, BJP party. Bharatiya Janata Party. Now, the explanation which has been provided by the petitioner in her written statement, my lord, find at page number 57.
Jila Parishad members cannot be there cannot be a Jila Parishad member of BJP. They may be elected from the BJP political party or IC. But the moment he or she is elected, she is ZPM.
Yes,
Not ZPA, he or she cannot be a ZPM of any political party, elected from that political party.
Well, the basic.
You read it, the impute order, page 31. We do understand ZPMs of BJP Tirap. No, same thing. It has been quoted. Page 80. And she has signed not as a BJP, she has signed as a ZPM of 6 Kapu block.
My lord, will kindly read the entire letter as a whole.
But the entire letter has not been taken into account. These 3 words has been taken into account.
There is
That
one,
what is it? Would you understand?
it should be read the undersigned.
Huh?
It should be read the undersigned.
Then
That is.
the deputy commissioner, we do understand. ZPMs of BJP Tirap.
Sorry, my lord.
BJP Tirap.
Yes.
ZPMs of BJP.
BG.
How can there be a ZPM of BJP
No,
or
she-
the Congress?
my lord, what she intends to convey is not ZPMs of BJP, but BJP, ZPM elected or
So you are the spokesperson of deputy commissioner, are you?
no.
Why you are explaining what she has intended and what she is not?
There's one more.
How you explain the intention of the deputy commissioner?
No, my lord, that is my allegation, my lord.
You are saying
Yes.
deputy commissioner intended to say this.
No, I'm on her no confidence letter,
Yes.
5th of April 2024,
Hmm.
not on the impunity.
Hmm.
5th of April 2024, she has submitted,
But she has signed as a ZPM 6 Kapu block.
no, there's other aspect to this. Why I am saying so? Well, altogether, there are 10 ZPMs in Tirap district. 2 of these ZPMs were elected on INC ticket.
See, this code is a form view that elected members cannot be just disqualified like that. Even if it's a summary procedure, some semblance of the principle of natural justice has to be followed.
But all cases which I have come across after the enactment of the Prohibition of Defection Act,
Hmm.
2003. In all the cases, below, there was no procedural requirement for examination and cross-examination. Decisions were based on.
No,
notice and subsequent
I'm
reply.
not only that it should be cross examination and cross examination.
My lord, it is the allegation of the petitioner that she was not allowed to make her submissions and they were asked to leave the office chamber of the deputy commissioner.
Yes, that's the reason.
That is the allegation, my lord. But such allegation, my lord, now give rise to a seriously disputed question of fact. Because my instruction is, my lord, she was duly represented by a counsel. The counsel made exhaustive argument. And it is only after the closure of hearing that all of them left together.
Yes, we'll see the record. We'll call for the record. Proceeding. All right. Heard, Mr. You want to give the judgment?
Yes,
Give which paragraph?
32 and 33.
Heard, Mr. C.W.
And there are some other
Mantha.
judgments, my lord, may allow me to place.
Yes?
There are some other judgments which I will be relying on. My lord, may allow me.
No, at this stage, no. Heard Mr. C.W. Mantha, learned counsel for deputy. And also heard Mr. S. Learned senior government advocate for respondent number
1 and 3 laws.
1 and 3, Mr. R.L. Thungan, and also and Mr. R.L. Thungan. For respondent number
4, 5 and 6.
4, 5, and 6. Come on. Challenge made in this writ petition is to the impute order number so and so, page 31, huh? Dated 29/04/2024. Passed by the Deputy Commissioner, Tirap District, Council. Whereby the petitioner is disqualified as being a ZPM of Kapu. It is 6 Jila Kap. Is it what? Kapu what? 6 Kapu.
Yes, Your Honor.
ZPM of Kapu 606
06.
Kapu ZP block. Sit up. Under section 6 within brackets. 2 bracket clause of the Arunachal Pradesh local authorities within bracket prohibition of defection within bracket Amendment Act, 2006. The original is 2003, 2020, as amended in 2026, huh? Issued notice returnable by 4 weeks since Mr. S. Tapinlan, Senior Counsel, and Mr. Aril Tunga enters appearance on behalf of respondent number 1
And 3 laws.
1 and 3.
2 is
And-
by name the Deputy
and-
Commissioner.
And 4, 5, and 6. No formal notice need be served, however, extra copies be furnished to petitioners to take steps for service of notice upon respondent number 2. Heard the pair for entry. Next pair. Mr. C.W. Mantok, learned counsel for the petitioner, submits that except for issuance of so cause,
Show cause.
comma, to which the petitioner has filed a written reply, comma, no opportunity of hearing has been given to the, provided to the petitioner. Mr. The impugn order has been rendered particularly on the basis of the no confidence motion notice issued along with no confidence motion notice submitted by the ZPMs, Jila President members, 7 Jila President members amended against the present, still there.
Yes, Your Honor.
ZPC is still there.
She's still there.
The present ZPC, wherein the petitioner has also put her signature. List of. This is prepared by whom? This letter, page 80. Led by you.
Worship, page number 80.
Yes, letter for no confidence motion.
No, no, Your Worship, it's not me.
But your name is in number one.
Yes, finding in inferior order that she came personally along with 17 committees.
Page number 80, Your Worship.
Yes. Your name is still number one. Letter for no confidence. Page 80.
All right, my true that copy is at page number 81.
Hmm.
Yes, my signature is there, Your Worship. My signature is there, but then in the capacity of ZPM of Kapu block, not as ZPM.
Yes.
BJP.
Wherein? It's your submission.
Yes.
She had put her signature in the no confidence motion. In the notice to no confidence motion. Listen. Next para. What is your submission? You will see the record and
Now,
please
Lordship,
make your submission.
now Lordship has clarified laws. So for this no confidence motion is concerned, that letter. Here Lordship, in their reply, he denied. Now he has admitted that he has signed in the capacity of ZPM of that block. Lordship.
You cannot deny.
The petty,
These are to be examined.
Lordship, what I'm submitting in his reply, in her reply, it was denied. Reply to the so-called notice.
Mr. Estafet, Learned Senior Counsel submits that in the reply to the so-called, the petitioner has denied, and now the petitioner has admitted that she has put her signature. She has signed the no confidence motion. Mr. Then Mr. Arul Tungat, learned counsel for respondent 4 to 6 submits that. Since the provision of the Arunachal Pradesh local authorities so and so act 2000 provide doesn't provide for any particular provision. There is no requirement of compliance of principle of natural justice. List of the issuance of notice and allowing to file a written reply is a substantial compliance of the principle of natural justice. List of. He further submits that since the petitioner has admitted the fact. No, since there is a complete admission of the fact, no further examination is required, much less the cross-examination. List. He also further submits that the requirement of examination in chief and the requirement of cross-examination follows from the examination in chief. And in this particular case, provision of CPC is not applicable.
Indian evidence.
Indian evidence is not applicable. Next. Consider the submissions of learned counsel for the parties. Next paragraph. The impugned order no doubt has been passed after issuance of notice and the written reply filed by the petitioner. the ground for disqualification of the petitioner. The grounds for passing the impugned order disqualifying the petitioner is based on two facts. Namely, that there are only two members of INC in the Jilla Parishad concerned, and the defection of one does not fulfill the requirement of 2/3 members for exemption under section 5 within bracket 2 of the act. You said in the beginning, you said within bracket here and after referred to as so and so act. In short, defection, this local authorities act, and the petitioner has signed the application for no confidence motion against the sitting JPC is within inverted comma, we do understand ZPM sub BJP Tira, comma. Having considered such grounds, comma, this court prima facie is of the view that the grounds for which the disqualification, the grounds on which the petitioner has disqualified appears to be not German and is in violation of principle of natural justice. Mr. Should I mention this, your judgment, or you keep it yourself? Or though the learned counsel for the parties have relied on the judgment of the Honorable Supreme Court, at this stage, this court made appropriate, and this court is of the view that no reliance on the and same shall be considered on the appropriate stage of the proceedings. Accordingly, in view of the above, the impugned order so and so shall remain suspended till returnable date.
Obliged.
Lordship, short notice by issue.
Returnable by 4 weeks, 3 weeks,
3 weeks, sir.
3 weeks. 3 weeks or 2 weeks?
2 weeks.
2 weeks.
2 weeks.
Obliged.
My lord, by order dated 9/4/2024,
Yes.
I was given opportunity to file my reply,
Yes.
but I could not file till today.
On the prayer of Mr. T. Patil, counsel for the petitioner. Let's this matter after 2 weeks. So
Lordship,
as available her to, him
this
to
is-
file affidavit in reply.
Yes, ma'am.
MS GF Learning Additional Senior Government Advocate is present.
Lordships, that chance may be given. They
Yes.
have a status quo here, Lords, stay here in this matter, Lordship. This is easy.
Interim order passed earlier shall continue.
Yes.
That is one.
Last
But otherwise,
given
my
for filing since
Yeah.
2023, they are, they have.
The stand taken by them is totally against the Arunachal Pradesh Land Records Act.
Yes,
I would-
Maybe may not
Because
cross.
that's why I'm insisting on filing my reply.
Obliged.
Obliged.
I'm for the respondent lordship.
Yes,
Your Honor, I'm for the petitioner.
yes,
Your Honor, today we are supposed to file one affidavit.
you file it.
Your Honor, the petitioner is out of town. Her daughter admission.
Mr. Mr. Tishul,
Dismiss.
learned counsel for the petitioner submits that the petitioner is supposed to file an additional affidavit.
Additional.
Mr. No. However, due to no, however, since the petitioner is out of station for out of station, for which he could not file the same, therefore he prays for 3 weeks time, 2 weeks.
My lord, we have the certificate issued from the
You file
competent
it?
authority.
Lordship, a short date may be when since there is a stay.
2 weeks.
Since the petitioner is out of town for
Praise the
daughter
Lord.
admission. 3 weeks. It may be
2
listed
weeks.
3 weeks.
Make it 2 weeks. Why should we always, all the time, I should be away from the town? Mr. B. Jamal, counsel for the respondent is present. This after 2 weeks.
Obliged lordship.
Matter has become in process.
Lordship.
Right.
Lordship. I'm
You
praying
have
for
come back
withdrawal.
here. You
Lordship.
have joined here.
Yeah.
Have you joined here?
Yes, your Lordship.
Okay. True to your assurance.
Lordship.
And Mr. No, MS N. Anju, learned counsel for the petitioner, submits that the matter has become infructuous. Mr. In view of the above, and then accordingly, next paragraph, accordingly, the writ petition states disposed of, closed on withdrawal, on having been become infructuous.
Obliged.
Closed on having been become infructuous. Huh?
Obliged.
Sir, what is this?
This is, my lord, non-issuing of NOC, which is required to be produced for my promotion.
Hmm.
Since I was working,
You have
Here in the-
engrossed.
yes, working in the department for more than 18
This
years.
court has unfortunately passed an order in a similar matter.
Yes,
It goes against you.
that is different case.
No,
Here in this case,
Yes.
my lord,
essentially, I have decided that you are engrossed, and if the guidelines
yes,
and the notification issued by the government is not put to challenge, you cannot. You will have to. The NOC is required.
NOC is very
And
much,
in another matter, I said I have.
my lord,
They might have.
reason for objecting my NOC is,
They might have taken to appeal, but those orders were also challenged. I've dismissed that also. Yes, Mr. Tara. What about those notifications and which were under challenge and disposed of by this NOC requirement of NSA,
land and cross.
land encroachment for promotion and all those? No, I just wanted to know whether it has been taken to appeal or not. Both
Yes.
2 writ petitions where I had the privilege of hearing Mr. Tara.
My lord, in my case,
Same
The fact-
case.
fact is that I'm not an illegal encroacher. I'm an authorized encroacher, though I have not received the land
That-
allotment from the concerned government.
That is more dangerous.
But then I have, even the urban development department also given me an authorized to connection, water connection, every amenities connection after completion of my building. An affidavit has been filed by the department, this vigilance officer and the LRSO, they have not make any dispute that I'm encroacher of the law. I'm not an encroacher of the public premises. This is not that. And health department, they are respondent. They are only performer respondent. They have to consider my promotion. And department, they are only performer respondent, which I have occupied. They said illegal occupied. That I have already applied. In 1999, I have occupied. I have been given authorized by the estate officer in 1996.
You show us any documents that
Yes.
you are not an encroacher.
My lord, and that is Annexure 3.
Three.
Annexure 4.
Page.
My lord, Annexure 4, that is page 26.
Hmm.
This is Deputy Commissioner, for Deputy Commissioner, ESCNF. During those days in 2005, they are the estate officer.
Occupy.
Yes, I'm occupied. I'm occupying since from 1996.
On what basis?
My lord, during those days, the system for getting an allotment was, first, we should have to occupy the government land. then we applied for regularization. That was the practice, my lord. Then after that, land allotment was banned in the state. Since then, my case is pending for active consideration.
You get it
My
right.
lord, then come to my second phase.
See, you get the land regularized in your favor, then apply for the NOC. Until the time it is regularized, you have admitted that you are not only encroacher, you are the authorized encroacher.
Yes, authorized encroacher. Then, my lord, in page 27, this is the certificate again issued by DUDA, District Urban Development Officer. I have already completed my RCC building in that occupied area.
Doesn't matter.
And to me, my lord, this notification is just
Only-
who are encroaching
only-
demolish the government quarter, which has been occupied with the employee. That is not there in my.
I'm just informing you because of for your benefit only.
Yes.
Otherwise, I'll dismiss it
Yes.
on the same line. Admittedly, you are in occupation. You have not been you have not been allotted as on them.
Yes.
Matter in state.
When we go for the notification also, if any criminal case,
To-
vigilance case pending against me, then only it can be.
To succeed in this matter,
Yes.
you'll have to get those cases set aside by the higher court.
Okay, well, the health department, they want to file an affidavit. It's still not yet filed.
And Mr. M. Bajal, counsel for the petitioner. Yes. Mr. Who is one, who is two?
Mrs. Lordship, I'm appearing for number 1, 2, and 7.
MS P. Sangeeta, State Council appears for who appears for respondent number 1,
2,
1, 2, and 3.
7.
1, 2, 3, and 7.
No, not 3, Your Lordship.
1, 2, and
7. Press for and is granted 2 weeks time to. You are
No,
praying
Your
for.
Lordship, we have filed already.
Okay.
They have filed.
Submitted. She has already filed counter affidavit.
I am appearing for respondent number 6 and we will not be
Mr.
filing.
Come for an understanding counsel for land management for respondent number 6. Mr. So and so, counsel appearing on Mr. Tita from land understanding counsel for health department. Press for and is granted 3 weeks time to file affidavit. By the time judgment may be set aside. You should not pursue this matter. You should pursue those judgment to be put to appeal.
May I, Your Lordship?
Yes.
Not only the petitioner, Your Lordship, in this case, his son has also encroached the government premises. Your Lordship.
What does it make a difference? It is sufficient if you said the encroacher. Well, I'm not interested in the son and daughter. Just after 3 weeks.
I will ask.
The responsibility is file the affidavit on 7/5. But
You want to
given
file
the-
reply?
I want to file my reply.
Mr. T. Patil, learned counsel petitioner. Press for it is granted 2 weeks time to file affidavit.
Interim order may be continued.
Earlier. Yes. FCP.
Please, Passover method. Passover. The PP of there.
What is the matter?
The bail method, Your Lordship.
You are in jail for last 6 months.
Yes,
6 months.
yes.
What
209
is the
days.
stage of trial?
Consideration of charges.
Consider charge.
Yes.
Is yet to be. Charge is yet to be framed.
Yes.
Where's the PP? We'll take after some time. Inform them.
Yes, yes.
Santosh?
That yesterday's matter,
Yes.
the issue in fact came up for consideration. The temporarily it is by the Honorable Supreme Court, so I given temporarily because it's still pending. Well, this issue came up before this division bench of this Honorable Court in the year 2016, but it's number one, my serially numbered. Number one, this Honorable Court in the division bench decided, Lordship may just go to the last page of number one judgment. Number one judgment. Lordship may kindly take up the number one. Yes, I've given 4 judgments. Last page, para 20.
Yes.
With the above observations, we are now dealing with the bail application in question. The petitioner, I'm sorry, Manoj, just top paragraph, para 19. In view of the reasons and discussions made above, it is held that normally a person or accused should exhaust his remedy under section 438 or 439 of the CRPC before the session judge before making an application before the High Court under section 430 or 439 of the CRPC. However, in exceptional illustrated circumstances, a person can approach the High Court without exhausting his remedy before the session judge. That was the division judgment. This was checked before the Supreme Court. 2 judgments not being taken up.
Without existing his remedy before the sessions.
Yes.
This
Now-
was the sessions tribal
Yes.
in these cases.
Yes. But then issue was whether in 439 petition it can come out directly here. Now, number 2 judgment also will be taken. This is a judgment by the Honorable Supreme Court, where an SLP was preferred by the Guwahati High Court Bar Association. By this order of 1st of March 2023,
Yes.
this notice was issued. And second page, Lordship may kindly see, second page on top. In our view, a decision on the aforesaid issue would have wide ramifications. Therefore, at the oral request of the learned counsel for the appellant, we deem it appropriate to implead Union of India as a respondent in this appeal. Let notice of appeal be served on the office of the learned Solicitor General of India, returnable After 6 weeks, in the meantime, liberty is granted.
This is against the judgment.
the judgment.
Okay.
Then next, number 3, Lordship may kindly see where there was this interim stay, madam.
Hmm.
This was an order of 2017. The operation of the impugned order is kept in abeyance until further orders.
Yes.
Then I have given one judgment, a recent judgment of 2021 of the Honorable Supreme Court. Lordship may kindly turn to the last but one page. Serial, I mean, paragraph numbers are not given, madam. Last but one page on top, my lord. We have heard the learned counsel for the parties at length and have perused the record. The jurisdiction of the trial court as well as the High Court under section 439 of the Code of Criminal Procedure is concurrent, and merely because the High Court was approached by the appellant without approaching the trial court would not mean that the High Court would not have considered the bail application of the appellant. And my lord, in fact, after the division bench judgment of this honorable court was kept in abeyance, this honorable court has been entertaining application under 439 directly. So in that way, the matter, because since the matter is sub judice before the honorable Supreme Court, the practice followed now is that the applications are entertained. Possibly, without entering into the merit of this lordship, entertain and decide the application on merit. After this, the order passed by this on Supreme Court, keeping in abeyance the order, division bench order passed by this honorable court. This honorable court is in fact entertaining application directly, madam. There are some judgments of the some high courts, madam. If it is post committal, then the trial court should consider the application. If it is post committal, then charge sheet is submitted, then the trial court will consider the application. Oh. Was an episode. In fact, my lord, in the division bench judgment, the reason for taking the view that the petitioner should exhaust the remedy before the sessions court first was given in para 16. Para 16, if your lordship kindly comes to mind. The above figures display that yearly there is a great deal of increase in the number of filing of bail application directly before the High Court, and it consumes a large chunk of the judicial time for disposal of bail applications only. Almost 2 to 3 benches are regularly constituted to deal with the bail applications. There is a huge pendency of criminal appeal before the division bench, and criminal appeal, criminal division, and criminal petition before the single judges. Besides, there is huge pendency of civil appeals. Not usually, this High Court has always functioned with a full sanction strength. There is always dearth of judges. There are concurrently 3 outlying benches where judges have to be deputed to deal with the work of at the outlying benches. It is therefore necessary that normally a person accused should file an anticipatory bail application under section 438 of CRPC or a bail application under section 439 of CRPC before the session court, and thereafter he can approach the High Court. However, this is not an inviolable rule. In exceptional circumstances, a person accused can directly approach the High Court. The following are the circumstances under which a person accused can directly approach the High Court. When a person accused from the other state has to move an application for grant of anticipatory bail under section 438 CRPC, if it is convenient for him to move such application before the High Court directly, which is necessary to nearer to any point of distance, such application should not be rejected on the ground that he can approach the sessions court. Wherever in a sessions jurisdiction a particular incident or crime is attracted a lot of public and media attention with an adverse public opinion having been built up against the accused. In such cases,
Okay, man, thank you.
madam, lordship, here my learned friend, he is the petitioner. He will give you. I take leave.
Now, Lordship, the fact is, Lordship,
Huh?
I have been languishing in a jail for the last 1 week, Lordship.
Huh?
I'm languishing in the jail for the last 1 week, Lordship.
Last
now-
1 week.
Lordship. Now I'm in judicial custody, Lordship.
Last only 1 week.
Lordship.
Okay.
Now,
Yes.
Lordship, this is the case where in fact, I was supposed to be a complainant, but the complaint has been filed before me so that I became an accused, Lordship. The medical report, Lordship, in the petition, Lordship, will find that clearly shows that I was subjected to the physical assault by the complainant, Lordship. And then incident, Lordship, this incident, so far as section 326, 385 to 86 is concerned, Lordship. The fact is, Lordship, it's not the allegation as per the allegation, Lordship. The fact is, after I came to know that he's already married, Lordship, I tried to burn down the car of the complainant, Lordship, not the accused, or not the complainant, Lordship. So in the meantime, he snatched the petrol bottle from me and the lighter just lighted up, Lordship, suddenly, Lordship. This is the incident, Lordship. Now my police remand has already been completed, Lordship. I'm in the judicial custody. Now the further interrogation, Lordship, keeping me in the judicial custody, Lordship, it will hamper my career, Lordship, because since I'm preparing for the state civil service examination, Lordship.
Preparing for what?
State civil service examination.
State civil service exams.
Examination, Lordship. Examination. I graduated in the year 2019, Lordship. Thereafter, I started preparing for the examination. In the meantime, that complainant he posted at the Procedural, Lordship, he started to contacting me, Lordship, and then he concealed the fact that he is already married, Lordship. He had a physical relationship with me also, Lordship, concealing that fact, Lordship. When I tried to file a complaint before the OCPS concerned police station, Lordship, OMPS, Lordship, the family member of the complainant, they urged me and not to file a complaint because since he is a government servant only.
Now you have filed.
Now after he filed a complaint, Lordship, I have left with no other option, Lordship. I have also filed a complaint.
Now you have filed a
counter FIR.
Counter FIR.
Lordship.
Where it is?
Lordship will find at page number 28, Lordship. Annexure 4, Lordship.
28.
Page number 28, Lordship. It's a very, Lordship, the content is very long, Lordship, so I'll not trouble your Lordship, the entire content, Lordship, but the allegation is, Lordship, sexually assaulted me. I was subjected to physical assault also, Lordship.
Yes.
Lordship, I have the case study, Lordship. Here, Lordship.
Here in the case diary.
Lordship, case study, Lordship. Here, Lordship, the accused, Lordship. He's stated that his wife of Hilang Ravi, the accused, Lordship. As Lordship, now the petition, Lordship, he just stated that they are in a relationship, Lordship. But here, Lordship, is a wife of Hilang Raj, Lordship. And the rented house, Lordship, which is claimed to be her, Lordship, is per the statement of the victim,
The
Lordship.
petitioner claims to be the wife of the accused.
Lordship. And Lordship, moreover, Lordship, in the statement of the Lordship victim, he claimed that rented house is he, Lordship. And Lordship, his Lordship may got statement of the
According
court.
to, is he not a
To see, Lordship.
is entitled or not now?
Lordship, I am objecting, Lordship, this bail, Lordship.
Why?
But this is the in this stage of
If she is
investigation.
a wife,
Lordship, is the Lordship
what is the extent of injury?
Lordship 30?
In ICU.
It is
Since I'm not in with the record, I have been informed by the complainant family also, Lordship. The burn has been on the, not on the ligament part or other part, Lordship, on that part, Lordship, where the petrol has been fell down from the hand of the complainant himself, Lordship. Now, subject to what my learned PP has submitted, Lordship, whether the custodial interrogation at this stage, Lordship, my statement has been recorded. Statement of the witnesses has been recorded, Lordship.
no, Lordship, no statement witness recorded yet, Lordship. Only statement of the accused and the victim, Lordship. Only.
I don't know when the IO has written the custodial interrogation.
It's
Is required
serious.
or not, Lordship. I don't know.
No, it is required. Still, investigation is still pending, Lordship.
You wanted to burn the car of the accused,
Lordship,
but your statement say you want to commit suicide, you want to using
Lord.
the petrol.
initially, Lordship, the complainant, he thought that I'm going to commit suicide, Lordship.
I think we'll wait for some time. The bottles and it's not been recovered. You have
Now, Lordship, my
thrown away the evidence.
Lordship, now my only question is that,
I'll
Lordship.
dispose, if you want me to dispose of, I'll dispose of and reject it at this stage. But if you want to try it, do it next week, after a week. It's initial stage.
Lordship.
No other witness also. No examination by the police. Only you and the accused. And the man is still in ICU at Guwahati. The accused. Oh, sorry, victim. They're
complete.
43% burn
Lordship.
as per the MLC.
Lordship.
It's,
Now, my only whether the
I understand you are a lady.
keeping me in a
you
jail,
are
Lordship,
preparing for examination, but there's a statement of you in the petition. There's a contradictory statement in your in the petition and the statement under 161. Something wrong. We'll consider. Wait for some time, or should I reject it?
Lordship.
Huh?
Lordship, this matter will be taken up after a week, Lordship.
Huh? On the prayer of Mr. G. T. Garam, learned counsel for the petitioner. List this matter after 10 days, after a week.
Lordship.
CD.
See,
Learned SLP to return the CD. This is the original.
Lordship,
Return the
update
CD.
updated CD, Lordship.
And place the updated CD
Lordship.
on the next date fixed. After 10 days.
Lordship.
Things
Like-
might improve. Otherwise, when is initial stage?
Lordship. Deeply obliged.
Yeah, Lordship, service need to be completed, Lordship. I think
Yes.
service has completed, Lordship. The victim has been made party,
Service completed.
Lordship.
Yes, Your Lordship.
Which one?
The respondent number 2, Your Lordship. The father of the victim.
So what is to be done?
So, Lordship, here, Lordship, no, Lordship, we have not called any Lordship now, Lordship.
So we'll call for the scanned copy of the
CD,
trial
Lordship.
code record.
Cycle record,
Charge
Lordship.
sheet has also-
Lordship, Lordship.
Right?
Yes.
We'll see.
And he,
Man is behind you since last 6 months,
8 months, Your Lordship.
8 months.
Yes, Your
Lordship,
He was arrested on 11 September.
No doubt under POXO, but then facts and circumstances. Different.
as per the Lordship, this under POXO, 1 year.
The
minute-
so and so learned counsel for the petition. And also Miss MS El Hage, learned additional PP. Service. Service number 2 is complete. List of call for the scanned copy of trial court record list of considering that the accused is in jail since last 8 months. Come on.
Yes.
Let this matter be listed after a week.
Lordship,
Yes.
obliged.
Right.
May I please, Your Lordship?
Yes.
Hearing for respondent number 2, 1 and 2, Your Lordship. Your Lordship, I beg to pray for the withdrawal of our affidavit, Your Lordship, filed on behalf of state respondent, Your Lordship. I want to withdraw my affidavit filed on behalf of state respondent, Your Lordship.
State why?
Because, Your Lordship, in advertising, Your Lordship, the uncorrect corrected copy of the affidavit has been filed, Your Lordship.
What is the procedure? Ms. Duncan? Can it be allowed like this?
My lord, I honestly don't have any idea.
What do you say, Mr. Nigo?
My lord, it's a record before the court and it's a lordship no matter what to do.
Yes, Mr. Sarkia. Is it permissible?
No, Your Lordship.
Anyway, my lord, in this case, yet another more, one more respondent is yet to file affidavit, that is respondent number 3, the land department. So in the meantime, if they wish to amend, let them, if the honorable court permits, then let them.
Why you want to withdraw this?
Because Your Lordship, whole body is, we have to change whole body of the affidavit, Your Lordship.
So that is also not
It is
permissible.
an unsettled affidavit. Your Lordship. Correct.
My lord, that
copy
is, I
ready,
think
Your
not,
Lordship.
that is not permissible.
Have you filed the reply? Have you got the copy of the affidavit?
Yes, I have
That is
received,
incorrect.
I have received.
Did you file the reply?
No. I'm petitioner, so I just,
Reply.
no, I have not
Affidavit
filed.
reply.
They have
No,
not
no.
filed.
You don't want to. You don't want to file.
Yes,
don't want to
no,
file.
no.
You are happy.
I'm happy.
Because there is interim order, Your Lordship.
What is the issue?
See, eviction order, Your Lordship. They are challenging.
Anyway, find out what is the procedure in such a situation. Not Mr. M. Nibo, learned. Well, we just cannot, I think, allow like this. Unless it is inadvertent, I mean, glaringly inadvertent mistake kind of thing.
Yes, Your Lordship. There are so many clerical mistakes, Your Lordship.
So you
Even-
find out the procedure and the law
Okay.
and make a submission. All right. M. Nibo, learned counsel for the petition. Which one, Mr. MS?
I'm 1 and 2, Your Lordship.
The Sangita, registered counsel for respondent 1 and 2. Who submits that she may be allowed to withdraw the affidavit while affidavit the respondent number 1 and 2. MS
5.
Endang and land counsel for respondent 5. You have also filed affidavit.
I file affidavit.
For 6 and 7.
Mr. Science for 6. Mr.
3.
Mr. Science respondent. Then you, after this Sangita, you write Mr. Kabuk, then Endang, and then you don't want to file.
No, my lord, because it's connected to lane matter, so the line that let the affidavit
They
be
are
filed from their part also.
This is order, Your Lordship.
It's good for you if they don't want to file. Mr. Dika, standing counsel for land management, bearing on bearer tsunami. Some is that he would not be filing any affidavit, rather would rely on the affidavit filed by the state. Unless this matter after 3 weeks. So as to enable the learned
But
state
then,
counsel.
my lord, what
to-
I feel is that the land department, if filed, it will
Huh?
be more better. File whatever may be.
So as to enable Mr. MS P. Sangita, London State Council, to have some research on the law, procedure and law with regard to the submission made by her. You find out
Obliged.
My lord, earlier interim order
the
may,
order was let's continue.
may be continued. Most of the
Yes.
Only played for 1 week time.
For what?
Lordship, since we were unable to receive the.
All the respondents. Heard
All
Mr.
those-
K. All respondents in the sense. So you are appearing for all the respondents.
Only for-
Last time he appeared already.
I appeared for praying for time to file wakalatama. Now we are unable to secure the signature of all the respondents. So only for few respondents, we will file wakalatama on Monday for the
For
respondents.
other respondents.
Not all the respondents. only
This is
few.
very likelihood, my lord, that a single counsel will appear. Is because this is pertaining to title suit. Dependents, the respondent or dependents.
You secured the wakalat number in the due course of time.
Yes, my lord.
And appear for. Since we did it already recorded. Heard Mr. K. Tama, Land Counsel for the petition. Mr.
Yes.
T. Getz, Land Counsel. Instruction appears on behalf of some of the respondents. And prays that he may be granted a week's time to while his power.
Interim may be continued. There is an
Interim order.
Well,
Interim order plus the list will continue. List after. No, before that, list after. Interim order plus the list will continue.
Hello.
My lord, it is regarding some typical error took place during petition date of birth. Yes, certificate state. Actually, her date of birth was 29/6/2000, but inadvertently it is entered 29/6/1994. That is the issue, your lordship.
You are supposed to file affidavit.
Yes, your lordship, I filed that I have taken
Regarding
steps
justice
by
service.
justice service.
Regarding
especially
justice service, lordship. yes,
Justice
I-
service as well as through register ID post.
You have filed the affidavit.
Yes, your.
Where it is?
I filed today, your lordship. This is my,
Today to, in that case,
yesterday we have filed.
no, it's Mr. A. Bhattacharya, Learned Counsel for the petitioner. It's not on record.
I filed.
You have filed today only.
Yes, your lordship.
So obviously. We cannot take that like that. That this. And also had Mr. MS Arbora, Learned Counsel for respondent
That's 1 and 2.
1 and 2. Which for only one,
Only
two.
two per respondent. CBSE,
CBSE lordship. I understand.
1 and 2.
one and
Standing
two.
counsel
So you are
for
appearing.
justice. Yes,
Then what's there?
yes. Lordship, I have received the notice by registered post.
Okay.
So,
No, then in that case, had Mr. A. Bhattacharya,
Yes.
Learned Counsel for MS Arbora, Learned Counsel enters appearance on behalf of respondent number 1 and 2.
CBS.
The notice is, the service is complete. Service is complete. List of,
3 weeks time may be allowed to.
and
file.
the Learned Counsel for the respondents. And the respondents are allowed 3 weeks times to file the response.
Date is given lordship 7th of.
7th of June.
7th.
Okay.
of life.
Lordship, this is jail appeal on section 334(2), Lordship.
Hmm.
Yeah, Lordship, LSC may be appointed, Lordship. Legal aid counsel may be appointed for the accused petition, Lordship. applicant lordship.
So we'll have to appoint.
Lordship, the Honorable Court may appoint lordship because this is jail appeal. This has come up for the first time.
That's this is a jail appeal. No, this is an appeal filed by petitioner from jail under section 374 within bracket clause criminal procedure 1970.
The registry to directed to make the registry directed to appoint one LLC for that.
Against the judgment and order, judgment of conviction and sentence dated 12/09/2023 in Pasigat Special Court within bracket POCSO case number 11 of 2021 under section 354 capital A bracket 2 bracket IPC read with section 8 of POCSO Act. We call for the
TCR lordship.
call for the well court records. Next pair. Registry will appoint or discord will appoint?
Okay, registry, court may direct the registry
MS.
to lordship.
L Hage, London, additional PP, appears for state response. A state, Mr. Who are the legal aid counsel?
See, that list is there, lordship.
We'll just
with the-
appoint everyone,
Lordship.
since the appeal is from jail. Come on. MS Endangen is appointed as legal aid counsel. Then in that case, what is to be done? The victim or the informant is not a party also.
It will be made party lordship.
That's why.
Court
What-
may order for pleading.
Pleadment.
Yes.
Establish the notice for
The-
the number team is.
The registry is directed to take steps for implement of the informant oblique victim, victim oblique informant in the present appeal. After a notice be issued, let matter after 3 weeks.
Not sure.
In the meantime,
You don't need this paper, only
we
paper.
may be. your-
This,
Okay, papers of
Yes,
the
that's-
appeal to
yes.
the London, to London Late Council. Within this, 4 days.
Obliged.
Obliged.
Yeah,
My lord, this matter day after yesterday also.
yes.
Before yesterday, my lord. As Chief Engineer Highway PWD has filed his, my lord, extended IA for vacation, my lord, on court order dated 23/8/2021, my lord.
Yes.
My lord, sir. Well, the contention of the writ before the was that, my lord, the land and the standing assets have been acquired by the, my lord, authorities, and, my lord, no present to, my lord, the writ listeners, my lord.
According, my lord, the honorable court,
Let the order.
order, my lord. My lord,
Page.
page, lord,
Hmm.
second paragraph, my lord. This writ petition filed by the petition directs respondent authority to release the compensation amount of rupees such and such only to the petitioner for the assets that have been acquired by the respondent authorities for construction of the four-lane highway of National Highway 415, my lord. My lord, in fact, my lord, there was no acquisition proceeding, my lord, for construction of the state, my lord, because the National Highway, in the existing National Highway, the right of way has been taken over, handed over by the deputy governor to the well, this- the- the- road is for what also not a part for the reporting matter. It is the case of the petitioner that a public notice dated 2/5/2016 was issued by Deputy Commissioner cum District Magistrate, Capital Complex, Itanagar, by such and such, where claim and objection in the writing was invited from the general public in view of the proposal for widening two-lane road to four-lane dual carriage configuration of the Itanagar Bandargua section of National Highway 415 from kilometer such and such to such and such. In addition, there to the was also an individual notice for filling such claim. 16 by such. According to the claim made by the amount in respect of the petitioner was determined by the respondent authorities which have been intimated to the petitioner by letter dated such and such, issued by the Deputy Commissioner Itanagar Capital Complex under memo such and such, which letter is a reply given to the RTI application filed by the petitioner dated 26/7/2021. Information faced to the petitioner by the such and such referred to herein, which has been annexed into the indicated that this land fall within the lineage of such and such. This is where his land asset was minor. This is road of NS 5 from under construction of different one has been established for the building, CC from BT building, SP building, the position for the report to the respondent authorities have not paid the above compensation amount to the petitioner till date, though the petitioner has come to learn from newspaper report that literally under the road in which space petitioner's asset also falls has been handed over to the highway authorities for construction of the four-lane highway. I over landmine, and this hangover was also not put to the challenge minor by the writ petitioner. The petitioner apprehensions that the construction of four-lane highway may started by the highway department anytime, which may affect the petitioner's asset for which no compensation has been paid by the authorities to the petitioner. The case to considering the contentions raised with the
Okay, I've read it. This has been because you have the authority not paid the
compensation.
assessed amount. Have you got it now?
No.
Then
No, my lord, this is a very
what happened?
peculiar case, my lord, where the assessment was made in 2016, my lord. And based on that assessment, the central government and the fund is with the state respondent, my lord. There was a notification from the cabinet saying that the compensation may be disbursed after due verification. This is the order of the cabinet. The applicant did, he
again measure the land, everything, and now says, I will not pay the amount. Whereas central government has already deposited the amount.
Against that action only you are before this court.
Yes, ma'am.
Then we'll vacate this.
No, madam,
We'll
why-
vacate this, they will concern, because according to you, they
Yes.
because you have, your assessment already been, you have been, your compensation has already been assessed.
Yes.
4 lakhs, what is 41 lakhs?
Yes.
41 lakhs, 19,000.
Yes.
Well, you are entitled to consider that.
Madam, why?
Because at that point of time, perhaps since your entitlement was not disputed, and
Yes.
you have not been paid,
Yes.
therefore no construction. Now let the construction go on. We'll examine that your right,
Madam,
whatever is
may
there.
I request, madam,
Because it's
why-
in the public interest.
can the
Are
state,
you not facing the problem?
definitely, madam, but can the state government allow?
So they're not interested.
Take-
Action.
Take-
And if we would all, it will be public, against the public interest.
Otherwise, Lordship, what I'm praying is this matter may be taken up at 21st or 22nd. In time, case
No, no,
can
we'll
be disposed of.
decide that separately. Today we'll this.
Because
we'll dispose of the IA. Your right will be considered separately. Because you are entitled, you'll be
madam,
considered. But so far as the stoppage of construction, to halt the construction of this highway, which everyone is facing the problem, is against the public interest.
why they have come by this IA? Because contempt is pending. They have already, madam, dug up everything of no structure, nothing is visible.
No,
on
what
ground.
you want the money,
Definitely, madam.
Then-
That's the,
we'll consider your entitlement. Once it has been assessed, and clearly it says you cannot have more than this 41 lakhs. Whatever you may be the claim, you have said that this has been assessed, so you have not been paid. So unless it is paid, no construction. Now things are just something different now. Your entitlement will be considered.
this madam
separately.
will be, madam, because the contempt is pending.
We'll vacate it today, we'll list
The-
the matter after
everything,
one.
contempt will become infructuous, madam, all the contempt petitions, madam.
We'll see. Where on the IA now?
Madam, if this vacated, madam, the contempt petition also goes, madam.
No, where, let us not go for all this thing. What do you want? That's why I'm asking. You
No,
want the money?
otherwise,
You
madam,
want the compensation?
yes, otherwise,
And
madam,
do you
matter,
really want that the highway should not be constructed?
no, they have already constructed, madam.
No, it's not constructed.
They have, madam. That's why we have filed the contempt, madam. That's why we have filed the contempt. Because they violated the interim order.
May I submit?
No,
madam?
once it is, you have constructed, what's the question of?
No, not it is fully constructed, my lord, but we have constructed substantially, my lord. Now, my lord, the border, my lord, it is called, my lord, soldiering pavements is to be
Sir,
finalized. my-
why you have constructed it?
Because, my lord, I'll,
You could have come before construction, you have come to this court.
my lord, this.
After,
there- there- my lord,
after
there is
violating
some
the
delay.
court order.
But, my lord, the land which has been handed over to the National Highway, my lord, that land, my lord, their land, my lord, assess does not fall within the right of way, my lord, in which the land has been handed over to the, my lord, the high authorities, my lord. And, my lord,
They are not entitled for right of way.
Right of way, we are not claiming.
yes,
You have constructed,
my lord, his, my lord, properties fall beyond the right of way, my lord.
okay.
I have also annexed the photographs,
So
my
are
lord.
you saying that he's not entitled?
My
for
lord, that
compensation?
will be, my lord, decided by the, my lord.
No, whatever may be, agent
Yeah.
today. You say that since the land falls beyond
Right of way, my lord.
right of- falls within the right of way. Entitled.
Yes, my lord.
Is it?
My
If
lord.
he is entitled, my lord,
No.
then we also cannot construct a road, my lord. Because his land, my lord, does not fall within the, my lord, right of way, my lord. And
Therefore, he is not entitled to any compensation.
that will be decided by the deputy commissioner, my lord.
My lord,
My only concern is that, my lord,
it affected, my lord, beyond ROW, right of way. That's why the compensation was assessed, my lord.
Okay.
My lord,
It falls under the right of
Yes,
way.
no,
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 falls beyond our right of way.
beyond the right of way, my lord, this way.
Even if it falls beyond the right of
No,
way, you are
beyond-
entitled.
No, if it's beyond the right of way, my lord, then only I'm entitled to compensation. If it is, if within the ROW, I won't be able to
Yes.
get anything. man.
Even if you claim for that.
Yeah,
Within the right of way, he is not entitled.
no,
He cannot be compensated.
no.
But my lord, then, my lord, if it is beyond the right of way, my lord, and my lord, the highway doesn't want that land, my lord, why it should be compensated, my lord? Compensation is
They have
because-
already damaged property,
No, but-
everything, my lord.
My lord, we have annexed the photograph also.
That's why,
My lord, kindly for a moment peruse the photograph, my lord. He is at page 29, my lord. His property is still intact, my lord, which is beyond the right of way, my lord.
Now that will consider
My own,
main petition.
yes, my lord.
Will dispose.
my lord,
Will get the for
Uh,
construction. We don't know.
why- they have-
See, we don't know the on the ground.
now, my
You
lord,
say you are saying that they have already constructed.
Kind-
You're saying it is completed.
kindly appear, lordship, that there was an interim order of this honorable courts. Because structures, not only the building, other structures were there, my lord.
No, will only that it says in the it is that no constructions be under by responding chain. This will vacate. Them conduct. It will not affect it. If your land doesn't fall under the
They
right
have
of-
already wiped out all the evidences now.
No, no, my lord.
No, if it is done, we are helpless. How can we do that?
My lord, we have to very fair.
What can we do for?
Yes, my lord. My lord, we have to very
We
fair.
are
with
concerned
what-
only
my lord.
the construction. Right. So we cannot stop the
Now,
construction.
if your lordship, because this first matter is bit different, the second matter, the Divya Pola lordship, I'll just show one,
No, where?
their
This
petition
is,
only.
this is only in respect of first case only.
First
Yes,
case,
yes.
no, two, I have filed two IS, my lord.
Two IS.
What is the
In,
other?
in item 6, my lord, 264 also, my lord. My lord, before that, my lord, I want to clarify one thing, my lord. My lord, after my lord, spot verification has been made, my lord. The writ petitioner has, my lord, constructed a bamboo fencing, my lord, within the right of way, my lord. For which, my lord, it was, my lord, removed by the petitioner himself by taking, my lord, 2,08,000, my lord, as compensation for that, my lord, removal of the bamboo fencing, my lord.
Same order. It's the same interim order.
Yes,
Same
yes.
entry order, my lord.
Same. Now, lordship, I'll just,
My lord, my difficulty.
It's okay. We'll consider
I'll-
the main writ petition.
just, I'll want
We'll
to
fix,
show,
if we fix after 2 weeks.
show
We'll
lordship.
finish it off. And we'll vacate this interim order.
No, just
We'll allow
lordship,
them to.
the annexure 4, page 28, in the second case. I'll just show one, the map which they have annexed, lordship.
Yes.
This may kindly be perused, my lord.
Which one?
The,
This IA.
yes, in second case, 19, item 19.
Let us
Just, no,
finish the first one.
no, first one, the map is not clear, that's why I'm showing this one.
Yes.
Second, this is clear.
Second one. IA. IA. Yes, page
Page 28, sir.
28.
Yes. There one annexure. Your lordship can see the map.
Building of
Of the Divya Pola.
Ah,
Now,
Yes.
your lordship will see the 15 middle one, the middle mark,
hmm,
ROW.
hmm.
This is the ROW. And the road which they will touch is beyond this PROW. This is proposed ROW.
This is a dwelling house or a Commercial house.
commercial. It's affecting the land, man.
Anyway, it doesn't, that's what I'm saying. We'll consider your main petition, but then construction will allow.
Why I'm this 2001 matter, man, is 2024, man. That's what I propose is a lordship can dispose of the entire matter. Not now.
Today.
20.
Now, look at
Second.
it and you, next you choose the date, which you,
Like entire contempt petitions and all those will go on.
no, it's only, no, they only were on concern about the interim order whereby this court has directed. I mean, stop or debar the construction. Heard Mr. RCK, Land Council, Standing Council for that. The Standing Council, Land Council, Standing Council, no, Land Council for the applicant. And Mr. P. Tapo, Land Council for the opposite party, writ petitioner. Next paragraph. By filing this application, the applicant has prayed for vacation of the modification of the alteration of the order of this court, that is 23/08/2021, passed in WPC. Same order is there.
Yes.
In second I also.
Yes.
Then you take together, huh? We'll dispose the same two eyes, huh? This is item 17 and next one is 21, huh? Same. 21 is also on same date.
Yes.
Order of the
Yes, same.
order
date.
is
Yes, same. date.
in writ petition number 260 of 2021. And what is the 264 of 2021? The claim of the petitioner in the writ petitions, petitioners in the writ petitions that the compensation amount having been settled by the authorities in favor of the petitioners, same have not been paid to them. Mr. Yes. The case of the petitioners that is the land of the petitioner. No, the land on which the petitioner assets also for has been handed over to the highways authorities for construction of four land from Ikano to Bandanwa, particularly the petitioner's land, which falls within the chainage number 53400-53450. And what is the next one? Chainage number Next read petition. Just give the number of changes.
58840
588.
dash 5880
588
40
40
dash 5880.
5880. Having considered that this court, considering that no compensation has been paid to the petitioners by the authorities, despite the compensation assessment having been finalized for the assets of the petitioner falling under the above chainage number so and so, in the compensation assessment report of NS-405 from Bikino to Bandardur for construction of national highway. It has been provided that no construction shall be undertaken on notice. Chainage number, same, above two chainage numbers of the compensation assessment report of NS-15 from the turnout of Bandardur for construction of four-lane national highway. The learned counsel, Mr. Asweke, learned counsel for the applicant submits that. Sir, what is your submission?
My lord.
On what ground it should be vacated?
Public interest, my lord.
Apart from that,
Public
On
interest
merit.
plus, my lord, the land whichever handed over by the district administration, my lord. Within that, my lord, we have, my lord, started constructing, my lord.
submits that the highway has started the construction on the lane which has been handed over by the
My lord, by the deputy commissioner, by
deputy commissioner, capital complex,
capital complex, by my lord,
By-
dated 27/7/2000.
by the order,
Yes, my lord.
by dated
20
27
2021. my lord.
21. Mr. This is the construction of the road. Has already been started. And on being handed over by the concerned authorities. The stoppage of construction of such an important public road will be against the public interest. Therefore, he prays for modification, vacation or modification of the imperial order. Peter for consider appearing for the opposite party. Submission. Above changes. Also under the this the payment of the list of if further submitted, if the authorities are allowed to construct, come on, the proper assessment. No, if the construction is allowed, then what would happen? What will happen
Well,
according to you?
all the structure has already been, that will wiped out, there will be no evidence.
Allowed. Come on, the structures of the land and building, structures of the property of the petitioner shall all be wiped out, and no evidence will remain.
Yes.
For
They will say there was nothing.
proper assessment of the assessment for compensation. Having considered the submissions of landed council for the parties. Come on. No, consider the submission of landed council for the parties. Huh? Come on. Next paragraph. Petitioner. Payment of petition assist as per the assist 415 to budget for construction of 4-lane national highway system. The such grievance come up in my considerable would be considered in the main petition, which is main in the main petition. On an appropriate date. The construction of the 4-lane national highway 415 is in the interest of it is needless to observe that the private interest must yield to the public interest. In view of the above, considering the public interest, I'm of the considered view the authorities should be allowed to continue the construction, continue to undertake construction of the national highway, a 4-lane national highway from Eternal Bundle to the interim order 2308/2021 is well vacated, is vacated. it is made clear that the right, entitlement, etc. of the petitioners raised in the writ petitions herein above shall be considered on its own merit. Mr. The IA states allowed and disposed of. Internal applications are allowed and disposed of. Yes. That's all. That's all. We'll just simply bucket it and allow to construct.
Other matters,
In the main, the writ petition, the so and so, hard so and so, all of them. List this matter after. These matters after
this
2
1
weeks.
1 week, this 2021 matter.
It's up to you.
Yes, all we have all have filed their affidavit.
Then in that case, you record all their names. Just give the thing. It is stated in the word. No. It is submitted by the parties that the pleadings.
Yes.
Pleadings are completed.
The land department has not filed the affidavit, my lord.
No, they won't file.
But the land department is necessary part, necessary part.
But if they don't want to file, madam.
No,
No, in that case, you will not say anything. You will not say pleadings are completed. You will
no,
say,
yes, my
He's here, my lord.
"Let's
He
just
said
matter."
he won't be.
Yes.
filing, my lord.
Yes, my lord, I have to receive the instruction from the department.
You are the one who has acquired the land.
Not that's.
I mean, this is deputy commissioner.
That's what he stated, but he won't be filing affidavit, my lord. That's.
by virtue of an order issued by the Secretary of Land Management, whereby a modality has been given, my lord. Then, my lord, within right of way, no compensation, my lord. There is a modality issued by the Department of Land, my lord. On that basis, my lord, the process has been, my lord, done by the Deputy Commissioner, my lord.
But my lord, if they don't want to file, my lord, who can force?
In that case, you just delete that. On the joint prayer of London Council for the parties, let these matters be listed after a week or
Yes,
two.
after a week, my lord, please.
After a week.
Yes.
Lordship, my appearance may be kindly recorded.
You just give all your name and respondent number, huh?
Yes.
Yes.
Obliged.
Ma'am, देना से हो गया.
What is this?
My pleasure, Lordship.
Implement petition, my lord.
In item 22,
Yes.
Lordship, I am filing affidavit in opposition.
Okay.
It may be taken up on Monday, Lordship. I'm filing today itself.
Or Mr. Titithara, London Council for the applicant.
7th Monday.
MS N. Dungan, London Council appearing and London Council for opposite party,
6/2/97.
opposite party,
Six,
public petitioners,
yes.
number 6/2/97. Is submits that you are filing today.
Yes.
She would be filing her objection. Is it an objection
Yes,
or
objection.
objection to the IA during the course of the day, for which she prays for listing the matter on
Monday.
20/05/2024.
For disposal.
Prayer not being no, it's okay.
It will be-
Prayer is allowed. Let this matter be listed on
5th Monday.
Monday. 20/05/2024.
Grateful.
And the
And others,
main cases, Lordship,
main case
uh,
to be listed
in-
along with that.
yes,
List.
interim may be continued.
23/24, huh? Both this. let this matter be listed. Obviously, this will come along with that.
Yes,
List along with this.
but interim may be continued, Lordship.
Interim order passed in. Earlier shall continue.
100 kilometers away from international border, Milord, no consent is required. There is a notification.
Okay.
So the case.
Let him be implemented first.
Who are you?
He says he's the contractors.
You are
Against
you are the contractor.
I am the
Yes.
bidders. I am the bidders.
Okay. Bidder.
Without making us a party, they have filed this
Okay.
read petition.
You are a bidder.
I am a bidder.
It
Tender
is-
has already been done, Milord.
Okay.
Our-
It's the tender is completed.
No, Milord.
No, not.
Okay. It's under process.
Yes.
Under process.
Okay. Okay.
Grateful.
29? It has been mentioned. Oh, 29 is not mentioned. 29 mentioned नहीं है. 29 is not mentioned. No, somebody may have mentioned this thing. Why don't you settle?
May I, Lordship?
Yes.
Lordship, like we have settled, we have given the principal amount. The principal amount was something around 1 crore 70 lakhs, that which we have paid. But since Lordship,
1 crore 60 lakhs.
1 crore, that was 1 crore 70.
What is that? What?
1 crore 70 lakhs.
70 lakhs. You paid 1 crore some 7 lakhs.
70 lakhs. We have paid the principal amount in
The
full. Lordship.
1 crore 9 lakhs.
That, and
Six-
after during,
61 you are,
that also we have paid, Lordship.
61 also you
We have,
paid.
we have paid that.
Now the interest.
Interest.
Interest, why don't you settle?
Lordship, the,
Forget about the pre-suit interest.
yeah, that's what Lordship, we are on.
A
for
lump
that.
sum interest you settle. Why is this?
Lordship,
Unnecessary.
I'm ready to pay the lump sum interest, but the interest which the learners, civil judges.
These are all, and it's not your, according to him, I don't know, right? It's not your hard-earned money. It's
That's-
your share only. According to them. We could understand if it is your really your hard-earned money. I'm not saying that share is also not hard-earned money, but there's a, I mean, thin line, isn't it?
Yes.
So I wish, I mean, that minus this pre-suit, the interest, you settle the interest, whatever is there. Do you have any proposal?
Lordship, we are ready to pay him the interest, like, not the, like we are paying the lump sum interest, Lordship. We are ready to do pay. We have no issue on that, Lordship. But the respondent, that is plaintiff is not agree, Lordship.
So what do you say? You are not agreeing.
Well,
Can
it's
you
not-
make an endeavor?
I-
Can you make an endeavor?
I don't think so. There's any scope for.
Lordship, this
Coming to
honorable
a-
court may pursue, Lordship, because
Because principal to you have received.
Yes,
There's no
No dispute.
dispute. It's only interest.
the only dispute is whether 3.5% in pre-suit interest decreed by the Learned Trial Court is correct or not.
Ah, yes. No, that's why I'm saying it's okay. Considering it's too harsh for the defendant or the appellant. Pre-suit. You may be entitled to some interest. So instead of going into the legality, we'll direct you to make an endeavor. If it fails, we'll consider it on merit. All right. What do you say?
Yes, I have to take instruction.
No, that's why we'll say, we'll not hear it today. We can hear it and finish it off, but then I feel it's in between individuals, not involving any public interest at large, right?
yes, Lordship.
And it's about money only, is not it? And it's not a violation of any, I mean, your property, depriving the property and other thing. So considering all these things, will direct you to make an endeavor. If not, we'll consider it on merit. All right. Heard Mr. V. Jamal, London Counsel for the appellate, and Mr. R.L. Tunga for respondent.
Sole respondent.
Yeah. Considering the issue involved in this appeal, that appeal and particularly the issue to be determined as to whether the pre-suit and the interest on pre-suit granted by the trial court is in accordance with law or not. And that the principal amount have already been paid by the appellant to the respondent. Let this matter be adjourned adjourned for 2 weeks. So as to enable the parties to make an endeavor to settle the matter. Settle the matter. List after 2 weeks. You talk to each other, and if it's not, if you agree, it's well and good. If not, we'll consider on its own. All right. Develop.